Hello YouTube, I'm Vince White. I'm an employment attorney, and on this channel we answer publicly posted questions from YouTube users, getting folks the answers they need from an employment attorney. Now today we're kind of playing an evidentiary game called What About My Evidence? And so bright. That has value because I think this conversation and running through a few of these hypotheticals will help folks to get a slightly better grasp of how to think about, work with, and generally just know how to deal with evidence and thinking about evidence. Okay? Not the most eloquent way to say that, but we got there. All right, so we have a question from YouTube user Amy, who asked us, "Thank you, Vincent, for your excellent education." Oh, thank you. My education was relatively lackluster. Not the fanciest law school. Undergrad was pretty good. Amy goes on, if the supervisor booked the hotel and ordered staff to go to his hotel room, the staff did go to his hotel room, and the supervisor attempted to rape the staff but failed, and a few days later the staff was suspended, can this be used as strong evidence in court? Thank you. Yes. So that's a complex hypothetical. And it doesn't seem like it at first, because like the first time you read that, you're like, yeah, of course, that's proof. Yeah, come on, right? But you need to take it and apply it to the elements of that claim, right? So supervisor booked a hotel room. Already sketchy. Already sketchy. And then he ordered the staff to go to the hotel room. I think already you could plug that into some of the elements for a sexual harassment claim. I think that's evidence of some highly questionable behavior from that supervisor. Now here we go, though. The next piece is the staff went to the hotel room. Okay. Well, listen, duress is real. Power differential is real. Certainly, I think that can be dealt with in the context of a sexual harassment claim. But Amy goes on to say, and then the supervisor attempted to rape the staff. So now we've already been demonetized because we're talking about rape and sexual assault. So thanks, YouTube, for that. Why would we arm people with their legal rights in those scenarios, right? Why would that? I get it, though. They got to run ads, right? And I guess people don't want to run ads on videos trying to help victims of sexual assault. Yeah, I'm still chewing on that one. Okay, so if you're trying to prove the sexual harassment case, booking the room, still solid. Attempted rape with a failure, booking the hotel room doesn't necessarily show attempted rape in any way. And the employee voluntarily going to the hotel room doesn't necessarily show attempted rape. Now, I would argue it does still act as a piece of evidence and could be couched in such a way, could be used to nudge a jury, an arbitrator, or a judge to think that there was sexual harassment here. Although some, certainly defense attorneys and some plaintiffs' attorneys would say, in this hypothetical, the employee goes to the hotel room voluntarily, and so that weakens the sexual harassment claim. I don't agree. I would say that's room for attorneys to do what attorneys get paid to do, which is reduce risk and add value to these claims. That is room to maneuver, right? That is room to do your job, to my mind. But I will say, let's not confuse the sexual harassment claim with the criminal charge of rape, which might be in play here. Those are going to have two evidentiary standards, and going to the hotel room voluntarily will not be as useful in the rape case, if there is one, the attempted rape case, thank God. It won't be as useful in that case as it would be, in my mind, in the sexual harassment case. Now, the staff being suspended a few days later after all this happened, that certainly adds a paper trail to all of this. So now think about what you've got here. If these are the only pieces of evidence you have, besides, of course, your client's testimony, right? Because this person that Amy is talking about, they're going to be able to theoretically tell their story, and that their testimony will then be laid on a framework of other data points, other evidence, right? So here you're going to have hotel bookings, paper trail. And you're going to have suspension, paper trail. And everything that happens in between is now going to be on this framework of paper trail, paper trail. Great start, right? Great start to proving that sexual harassment claim. The sexual assault claims, the rape claims, why stop saying it? Might as well keep saying it. Already demonetized. That's different. If you're in a state where there is a civil claim for sexual assault, you're going to need to talk to local counsel about what you need to prove for that. If you're pursuing a criminal action, you'll be speaking with the district attorney's office, wherever you are, the prosecutors, about that claim and what they need to prove, right? That's different. It's a little bit of a different world. We often cooperate and collaborate with those folks in really horrible situations, trying to give them what they need, arm them to put bad people behind bars. But it's not generally the purview of an employment attorney. It's a little bit offset, a little bit separate, but related occasionally. So in this video, what I really want you to take away, the plaintiff here is going to testify as to what happened. And the plaintiff can testify, hey, the boss booked a hotel room. The boss told me to come to the hotel room. I went. He tried to sexually assault me, tried to rape me. I got away, and then I was suspended. And then as the defense tries to attack that narrative, you frame it, right? You've got your data points. You've got your documentation. You've got your paper trail, hotel booking receipts, credit cards, so much, right? The GPS from his car, his GPS search history, the low jack from his car, the traffic cam, whatever you got to do to put him at the hotel, right? Booking the hotel, at the hotel, emails from the hotel, his points on his credit card, right? His Marriott rewards points, like whatever, like, right? This is important. When you're thinking about how to prove something, the limitation is your human imagination. The more you think about how to prove a given thing that you need to prove, a given element in your case, the more likely it is you will be able to prove that point. Depth of thought, time under mental tension on a given topic will yield results, right? We have this belief in human genius. Listen, there's some very smart human beings in the world. Here's what it comes down to, though. If you think about something in a variety of different ways for a very long time, you are exponentially more likely to come up with useful ideas than if you think about something briefly and don't get a flash of inspiration. Like, that's not... Do those people exist? Have great ideas come that way? Sure. Yes. The Da Vinci helicopter, whatever, right? Archimedes, right? Apples falling on Sir Isaac Newton's head. Sure. Genius. But I'll tell you what, I bet you Isaac Newton thought long and hard about the rules governing gravity. And I assure you, that calculus didn't come to him overnight. He was hiding out from a plague, as I recall it. Now, all of this is really meant to talk around how we deal with evidence. Going to give the usual caveat: hire an attorney who does this for a living. Please hire an attorney. Not me. Don't hire me. Hire local counsel. But hire an attorney. It will reduce the risk in your case so much. It will potentially add so much value to your case. It will also make this process easier on you. Hire an attorney. But again, not me, because I don't want you to be like, oh, that guy wants me to hire an attorney because he wants me to hire him. Do not hire me. No, I don't have anyone to answer your call today. We're so busy. But really, truly, hire a highly experienced, talented employment attorney where you are who can help you with this. Good luck. Like, subscribe, comment down below. It helps me to help more people just like you. Take care.